Good afternoon, members of the Committee on the Judiciary and Public Safety. Thank you for the opportunity to testify today on Bill 2710, the Limitations of Guardianship Amendment Act of 2014. My name is Henry Sabassi, and my colleague to my right is Razia Brumfeld. We are both student attorneys at American University's Washington College of Law's Disability Rights Law Clinic. In this clinic, we are supervised by Professor Robert Dinnerstein, who is here with us today. We represent families and individuals with disabilities in a variety of legal matters in the district, including alternatives to guardianship. Today, I will be discussing the importance of Bill 2710's time limitations on guardianship, while my colleague will advance supported decision-making as a viable alternative to guardianship. Bill 2710 honors the original intent of guardianship laws by providing the opportunity for persons with disabilities and their loved ones to consistently ensure that the limited or general guardianship in place is necessary and appropriate. We recognize that some individuals with dementia and similar disabilities that irreversibly diminish decision-making capacities will not regain or improve their decision-making capacity. However, some individuals with intellectual or developmental disabilities may develop additional decision-making capacity, such that a continued guardianship in its original form becomes inappropriate. This bill's 3 to 5 year time limitations are targeted towards such instances. In addition, state legislatures in Missouri, Michigan, and California currently have parallel sunset provisions in place. In addition to being a student attorney with the Disability Rights Law Clinic, I'm speaking in my personal capacity as the sister and soon-to-be guardian of an individual with autism and intellectual disabilities. In the past 5 years, my brother Ed has learned to count money, he can attend crowded functions, and he is now reading at a 2nd grade level. Though he is not currently in a place where he can live independently, with consistent and persistent efforts, we believe that he will only continue to improve. Though I do not permanently reside in this jurisdiction, as I reflect upon my brother's life and progress, I know that I would support a sunset provision on my future guardianship over Ed. In addition, we wanted to echo our colleagues' comments and address the concerns regarding certain individuals being left without a guardian. If this bill's provisions are put into place, we believe that language could be built in to permit the extension of a guardianship order until a hearing can be held within a reasonable period of time. In closing, placing time limits on guardianship will not only promote autonomy for people like my brother, but will also provide the opportunity for all persons with disabilities to make meaningful life decisions, avoid isolation, and access a life filled with independence and dignity. Thank you very much.
Thank you very much. Next.
Good afternoon, council members, and thank you for having us. My name is Razia Brumfeld, and I'm a student attorney with the Disability Rights Law Clinic at American University, Washington College of Law. In addition to time limits for guardianship, we are also concerned with those instances where guardianship unnecessarily limits the autonomy of individuals with disabilities. Too often in the District of Columbia and elsewhere, guardianship is imposed upon individuals who have the capacity to make their own decisions, but simply need a little help or support. Therefore, courts should require petitions for guardianship to have explored supported decision-making and determined that it would not be appropriate prior to appointing a guardian. Supported decision-making includes a variety of practices, relationships, and arrangements that facilitate people with disabilities in making their own decisions. For example, in a supported decision relationship, friends, family, and community support members all work with and assist individuals with disabilities in making their own decisions as opposed to speaking for them. This framework is consistent with the district's current guardianship laws, which encourages guardians to include disabled individuals in the decision-making process to the maximum extent available. However, by expressly including supported decision-making in the district's guardianship laws, we may ensure that guardianship is limited to those instances when it is completely necessary. Thank you, and we're available to answer any questions.
Thank you very much.